In Maidens versus Building Supplies Distribution Limited, District Judge Davies, sitting as Regional Costs Judge at the County Court at Derby, determined a contested interim application brought by the defendant within the provisional assessment regime under Part 47. The underlying personal injury claim had settled for £43,000 on a Part 36 basis, with the claimant's bill of costs totalling £56,460. The defendant's points of dispute were accompanied by an itemised Excel spreadsheet intended to achieve Ainsworth compliance, which the claimant's replies challenged as inadmissible at provisional assessment. The defendant applied under Part 23 for a declaration of compliance with Practice Direction 47, paragraph 8.2, and a strikeout of the non-compliant replies. By the hearing, the claimant had conceded the admissibility of the spreadsheet, leaving only Ainsworth disputes on points 7, 15 and 20. The judge accepted, following Rule 3.1, subparagraphs 2k and 2m, that jurisdiction to hear the application existed, rejecting the claimant's reliance on Practice Direction 47, paragraph 14.2, subparagraph 2, as a blanket prohibition. However, the judge declined to exercise that jurisdiction. He held that the provisional assessment regime, designed following the Jackson reforms to provide a streamlined and proportionate process, would be undermined by permitting preliminary applications to determine issues properly reserved for the assessing judge. The application was dismissed. The claimant was directed to file amended replies by the 6th of May 2026, and the defendant was ordered to pay the claimant's costs of the application, summarily assessed at £11,220. Quote, "To entertain this application, in circumstances where the dispute is suitable for provisional assessment, particularly in light of the concession made, would set an unwelcome precedent. It would encourage parties to bring interim challenges routinely, seeking to litigate issues by instalments, which the rules intend to be resolved in a single, streamlined process. That would undermine the provisional assessment regime, increase costs disproportionately, and place additional burdens on court resources."
For a detailed summary of this decision, visit tmclegal.co.uk.